Bob Kerrigan for Kerrigan, Estess, Rankin, McLeod, and Thompson. This brief video will discuss, or I'll discuss with you now, the Florida wrongful death statute, which is Florida Chapter 768.16. What is wrongful death? Well, it means the same thing as accidental death, and the statute was passed in derogation or opposite of the common law, because at the common law, when a person died, any claim that they had was lost, and there was no claim for the accidental death of another person, and that's been changed by statute. Each state has pretty much changed this, but each state is different, and if your wrongful death claim or accidental death claim occurs in another state, it's imperative that we consult lawyers in that state to make sure that we comply with all of the requirements to properly protect your interest in the event of an accidental death claim. Statute of limitations in Florida is 2 years from the date of the death, and it's very important. If that time expires, your claim is lost, and so it should be brought within that time. Investigation of these cases is critical that it be done early, because you lose track of witnesses and other evidence, and so the best thing to do where there's an accidental death, and the importance of it to the family is such that somebody be retained fairly early in a case that has experienced an accidental death claims. Florida Chapter 768.16, subsection 17 and 18 provide additional information, and one that I want to discuss quickly is what a survivor is, meaning who can bring a claim for damages. Survivor means the decedent's spouse, children, parents, and when partly or wholly dependent on the decedent for support or services, any blood relatives and adoptive brothers and sisters. It includes the child born out of wedlock of a mother, but not the child born out of wedlock of the father, unless the father has recognized responsibility for the child's support. This action has to be brought by the personal representative of the deceased. What is that? That's somebody the court appoints literally as the spokesperson for the family and the survivors to bring a legal claim against those that are responsible for causing the death. Subsection 768.21 provides a description of the damages, that is the monetary recovery that may be made by various people involved. Not any relative out there is entitled, as I said earlier, to make this recovery. It is limited unless those relatives have been supported by the deceased. The minor children of the decedent and all children of the decedent may recover if there is no surviving spouse. So what does that mean? If there are minor children, they make a recovery for the loss of their parental guidance, support, and love and affection. And then if there's no surviving spouse, adult children can actually make that claim for recovery. Each parent of a deceased minor child may also recover for the mental pain and suffering from the date of injury, and each parent of an adult child may also recover for the mental pain and suffering if there are no other survivors. That's under the Florida wrongful death statute. The statute provides who can make a recovery and how the lawsuit should be filed. At Kerrigan, Estess, Rankin, McLeod, and Thompson, we're board-certified lawyers. We are specialists in this field and experts in the handling of accidental death claims wherever they occur. We consult without any charge and without any obligation whatsoever. Kerrigan, Estess, Rankin, McLeod, and Thompson. Bob Kerrigan speaking for the firm, and thanking you for watching.